Hey everybody, welcome to the Bold Today show. This is our weekly show. We are here 9 a.m. Pacific and noon on the East Coast. And I'm JD Hoovener. I'm the host here. I'm the owner here at Bold Patents Law Firm, patent attorney, and happy to be here with you, inventor, entrepreneur, business owner. And we're here to answer live questions and answers for anybody that's out there. We've got broadcasts today across YouTube, LinkedIn, and Facebook. So I'm excited to get any of those live questions that come in. And while we are attorneys, by nature of joining the broadcast, you're not a client of ours. We're not going to engage in confidential legal consult, but I do welcome any question related to the process, how to get started, or anything in between on your entrepreneurial journey. We're also going to be published this on our podcast, the Bold Patents Show. It's on our new platform. So we were actually on Buzzsprout. If you've heard of Buzzsprout, I'll put a link out to that in just a little bit. I've also got my co-host here, Matt. Welcome to the show. Good morning, Matt.
Hey, morning. How's it going?
Well, I like those glasses. Are those new?
These are pretty old. I don't wear the glasses too much, but my wife does own a couple Pearl Vision franchises, so I gotta wear glasses every once in a while. But usually I'm a contact guy.
Cool, that's right. Well, good. Well, I have a pair of glasses, but if I'm wearing them, that means I'm really tired and sleepy. I'm heading for bed. Yeah, giving my eyes a break. Cool. Well, again, welcome to the show. If anybody doesn't know Matt, he's been with our firm for several years. He is our go-to trademark attorney. So we're sort of the 1-2 punch on patents and trademarks. We're going to tackle 6 questions today from our AVO question askers out there across the country. Where Matt and I are fortunate enough to have a practice area that's nationwide. So it's a really awesome way to get and meet and work with clients that are just fascinating from all over our country. And so it doesn't matter where you are, Bold Patents can help you with your intellectual property, patent, or trademark issue. Okay, so I'll put up a quick little legal notice here. I've already mentioned that with respect to who we are and what this broadcast is here for. If you're watching this after the fact and you want to hop on live, we're here Wednesday. Hit us up on the next Wednesday. Join us on our Facebook page. Bold Patents is the keyword. And hop on, have some fun. I see we have 4 live listeners now. Glad to see you guys. If you're first-time viewers, give us a like. Give us some thumbs out there. Let's share this with as many people as we can. I want to promote this and get information out to the masses. This is what it's all about. Matt and I will tell you that we are happiest when we have clients that are informed. The last thing, and this is the last thing, but things we don't like to do. Thanks for those thumbs up. I see those coming in. We don't mind educating and helping people along the way. That's kind of the nature of the biz, but it sure helps. My goodness, we can get right to the fun stuff if we're kind of already at the point to where the client is educated. That's why I've written all these books up here. And so that's why I'm doing this broadcast today. So there's no question, too simple. Don't be shy. I mean, we'll take them all on. The topic for today is provisional versus non-provisional. So it's patent-related subject. Matt, there's nothing like a provisional trademark application, is there?
There isn't. The closest thing would be an intent to use application, which basically means that you're not in the marketplace yet, but you're going to be going to the marketplace in the next, 36 months, essentially.
Yeah, cool. So we're going to be talking about provisional, non-provisional in a little bit, and maybe a little intro on intent to use versus the actual trademark application. We'll also be getting to the 6 AVO questions, but again, I'll be prioritizing those live questions for any of you out there that with burning questions, or maybe something you've been wondering about and you want to get answered. After watching, maybe right now, if you're excited, I've got a link for you. You want to take action and see if our firm might be a good fit for you. We want to see if you're a good fit for us. So we've got this process called the screening session. And so we're listening to what you're up to. And we're here about your innovation, hear about your new business, and see if what you have got going on is something we can help with. And so it's a free session, no obligation. What we do in that meeting is hear your story and see if it's something we can help with. And if it is, we'll recommend then you have a legal consultation. For doing that, for taking the action and scheduling that free appointment, we give you a free PDF to this book right there, Bold Ideas, The Inventor's Guide to Patents. It's like a basic tutorial on patent law and also the differences between the other areas of IP. So don't miss that. Click on that weekly live link and schedule it with one of our advisors today. All right. I also want to try to squeeze in a bold bite. We introduced that last week on our Shark Tank critique. I will note that YouTube, in their almighty robot AI goggles, and I shot this over to you, Matt, they did spot that for potential copyright infringement. And we could probably spend a whole segment talking about copyright and fair use. But as an IP attorney, I'm holding to my guns, right? I do believe that was a fair critique of the show. I don't think we at all intended to steal from the goodwill or even the artwork that's done by that great crew that produces that show. So we'll do it again. We'll do it again today, and I'll do it until I get in trouble, because I think it's important. You know, it's such a popular show like that. I think it's a great interest point. They present a great venue, and we're able to just amplify the work they do on that great show, Shark Tank, which is actually one of the major reasons why I got into law. I tell a lot of people that in my story. You know, I was in law school, and kind of wondering what kind of practice I was going to open up, and I kept hearing that patent question, right? You got a new product, new idea, new design. Is it protected? And started looking at what it would take to get that happen. So that set me on my journey to be able to become a lawyer, patent lawyer, and serve inventors like I am now. All right. So let's do this topic today. Again, those live question askers, bring those questions on. We're going to talk about provisionals versus non-provisional. The basic thing to understand about provisional, it is a less than formal. Okay, it does not require the full set of claims to file it. You do not have to have formal drawings. So the actual application, the specification, which is the fancy term for the written description and the claims, they don't need to be in a special format. You can really just write it in as much detail as you can, as you would a written work, a journal, a detailed technical description. The catch is that it must describe the invention so that someone could go build it. So it really does have to lay out the metes and bounds and enable an inventor, maybe not yourself, but someone in the field, to go make and use it. That's what's called the detailed description. Like I said, the drawings, the format, it's all kind of out the window. You don't need to describe it. The images, right? They don't need to be the perfect 2D drawings. They can actually be pictures of your prototype. They can be sketches, right? Anything you've got that will clearly articulate that words have a hard time accomplishing through drawings and pictures. What the provisional will do is it locks in for a year, right? To the date, 365 days. Don't miss that deadline, because within a year, you must follow it up with a non-provisional patent application that claims the benefit of that early filing date of the provisional. Reasons for doing a provisional: if you haven't built or tested your invention and you want to go see if it actually works the way you thought it would, that's a great opportunity, or great reasons to do a provisional. If you're looking to present your idea to third parties, investors, other co-inventors, right? You need to actually get this idea vetted some more. Then it's a great idea to get a provisional patent application filed. It's the best thing to do in terms of locking in and protecting that invention and the priority date. Okay, after the American Invents Act was initiated about 6-7 years ago, the whole patent law shifted from, it doesn't matter anymore who invented it first. It's all about who files it first. And so having that priority date filed with the provisional locks in that filing date. And that all important date is what will carry the day and will win, even if someone else invented it first. You're the one that moved and got it filed first. That's what will actually provide the grant, the actual right. The protection is the one that took action and filed it. So like I said, with provisional, it is generally more affordable. Working with our firm, it's about half the fee of a non-provisional. Okay, let's talk about the work that a non-provisional entails. This is when all the formalities are in place, and the USPTO will have a very rigorous standard on how that written description is laid out. You've got to have all the headers in terms of abstract, detailed descriptions. All the figures that you do show have to be numerized and called out in the description, showing exactly how it works. And then, of course, the claims. The claims have to be written very specifically and numbered, and that is really what will be the rights, what you actually own if you go after an infringer once your patent is granted. The claims is what you actually will own. So a lot of time should be and is spent on those claims. And then last but not least are the drawings. They must be professionally drafted, and there's lots of rules governing shading and how the lines connect and where the flag notes need to be, along with the overall formatting and the differences between when you can use a picture, when you can use color, when you can use black line, and all those different rules. So that is what must be submitted along with the non-patent discussion, which is the IDS is one specific document, the invention disclosure. So as the inventor and as the attorney, you have to, when you file a non-provisional, submit all the information you knew about your invention. So you got to give up all the information. They make you sign that you're disclosing everything you know about the field. So if you knew about someone else that might have disclosed your invention before, you're on the hook. You have to disclose that to the examiner. And that also includes anything that our firm might find in a patent search. So that IDS can be quite lengthy, but it really is a good faith showing to the examiners that, hey, this inventor is providing me this invention and this huge list of references saying that, yeah, what they've invented is truly new, and they couldn't find anything either. So it gives the examiner a good jumping spot. If you don't provide anything in the IDS, that does raise eyebrows, and it will generally be a concern when the examiner starts their search. So long story short, the non-provisional takes about twice as much work. For many inventors, the provisional makes the most sense, especially first-time inventors. It's a great way to lock in that priority date, give yourself a little breathing room, right? That whole year to decide whether the invention is really going to make it in the marketplace. If you need to bring in third parties to invest and believe in the idea and start your company. And then finally file the non-provisional. Now, for more experienced inventors or business owners that have got several patents, they've got a portfolio, they know how it works, they might file the non-provisional right away. They don't need to necessarily test their product. They may have already done it. They want to just move to the patent filing, the official non-provisional right away, in essence, saving themselves upwards of a year to get that patent granted. So that is one potential negative to the provisional. It's just adding more time before you get your right to grant it. Filing a non-provisional right away, you'll get that done sooner. All right, there it is. Provisional versus non-provisional. I want to also provide a little quick link to a blog article that'll go into depth a lot more, and I'll put that in here as well. Matt, can you speak briefly on the trademark side? I want to make sure we're balanced a little bit, in terms of timing on that intent to use versus actual filing. Any additional insight there on how that might play into or have a parallel to the provisional?
Yeah, absolutely. And I apologize if there's some background noise. We have the house cleaners here every other Wednesday, so which is great.
No problem.
But yeah, from a trademark perspective, if you're in the marketplace already and you have a product or service that you are selling, in a store, online, advertising at conventions, that sort of thing, then you qualify for an actual use application, a 1A trademark application. But if you're like a lot of our inventors and you have an idea for a business and you're working towards bringing that, dream to a reality, you'll file what's called an intent to use application, which is kind of like a provisional patent application. It means that you're not in the marketplace yet with the brand, but you will be, in the near future typically. And you're asking the government for preliminary approval to register your trademark. What that does is it gives you a first use date, which is really important, so nobody else can jump in front of you at the USPTO, and it gives you some rights in the brand before you even launch the brand, in reality. So we do that a lot for clients. The timeline for an intent to use application is we file the intent to use application. That's when your rights begin, the date of application for the intent to use application. It's typically reviewed about 7 months from application date, which is crazy long with COVID. That's kind of how the reality of it is now, though. And then once the application is approved by the USPTO, it's basically there's a 6-month time period between when it's approved ultimately and when you have to go to market. So, for most clients, you're probably looking at 12 to 13 months before you have to prove to the government you're using the trademark. Of course, we can extend the application, that intent to use application, every 6 months for up to 36 months. So you get quite a bit of protection with an intent to use application. And what I always find with clients is my clients are repeat clients, right? They know now that they want to file an intent to use application. So they're calling our firm early and often so that they can get that pre-protection and approval before they go to market. And it's also just for a larger conversation. It's what the big boys and girls do. All these companies like Nike, they're always filing their Apple, they're always filing their trademarks 2-3 years before they go to market. The main reason is because they want to be darn sure that when they go to market, that trademark is theirs. It's already been approved by the government, and that they can feel like they can invest those, tens of millions of dollars, hundreds of millions of dollars into that product line and not have to rebrand. It's important for smaller clients too, but for the bigger clients, that's huge.
It's always good to know that if you're a small guy or gal, you're doing the same thing as some of these bigger, really smart companies are doing too. So it's interesting to know. But of course, you are taking the risk, I suppose. You do a big intent to use filing and the business flops and you're on to the next venture. Well, you're out that money that you paid to hire, research and file. But it probably is well worth the risk. And what entrepreneur isn't a little, okay with some level of risk, and you have to do that.
So the intent to use application, it costs $100 extra in government filing fees, but that money is just well worth it because, I mean, I'm doing this 11 years. I can tell you horror stories of clients who drag their feet on filing their trademark applications. And between the time we had the initial conversation about filing and by the time they actually ended up filing or signing up to work with us, somebody else had jumped in line at the USPTO. It happens far too often, and it happens more and more because there's more and more trademarks filed. I think like 15,000 are filed every week in the United States. So that intellectual digital real estate, if you will, it's becoming smaller and smaller and harder to get. So I encourage you, if you're interested in a trademark, talk to us early and often.
Yep. Excellent. Good stuff, man. All right, let's go to, we're going to try to get to about 4 questions if we can. And why not stick with trademarks? You were just riffing on that. So let's do it. Speaking of riffing and music, that's what this question is all about. This is a question out of Milwaukee, Wisconsin. And this is about a DJ name, how to protect a DJ name. So let me bring this question up. We do have a question from Mark Osteller. Mark, let me get to yours right away after this, okay? Because I already pulled it up. Okay, how do I protect my DJ name? I'm new to the DJ world and I would like to use the same name people know me as in church. And that is Maestro. Maestro.
I love it. Cool. Yeah. So I guess it's probably no surprise, but I've worked with lots and lots of musicians and DJs over the years. And so in terms of, what your path looks like from a registration perspective, I can't speak to whether or not, Maestro is available for registration. That would be something that we would need to talk about separately and do a little bit more research for you. I mean, conceptually, it's a great name. It's highly suggestive of the services and the products that you do. When we talk about protecting musicians, artists, specifically, we're talking about 2 different classes at the USPTO. There are 45 classes of goods and services. Everything we do from legal services to apparel to music recordings falls into one of these 45 classes. You're specifically in class 41 and 9. 41 is going to be your live entertainment services, right? So that's when you're performing. That's the performances. It's the videos. It's the live performances, right? That's generally what it is, the entertainment services. But if you record music, you're also a product company or product individual too, right? And so you're selling those sound recordings, and that's going to be class 9. So think of yourself both as a product company and a service company, right? That's how a lot of the clients end up being in 2022, is that we sell both. So you're probably looking at 2 different classes, class 9, 41, to protect the goods and services.
Love it, man. So we are live. So we're doing, if you could call it, we're doing entertainment. Potentially the Bold Patent show is also recording. So we have both. Is that right?
Entertainment class 41. That's what this is. Cool. I don't know how much entertainment it is, but it's certainly educational, right?
Yeah, absolutely. All right, let's bring on one of our longtime clients and awesome participant here on the Bold Patent show, Mark Osteller. I wish we could somehow bring you on, right? To have you read this question, but what is the average timeline these days to get a response from the USPTO after filing an NPA? Also, is it correct that only after either an NPA or PPA is received by the USPTO is that when you can start using patent pending? Great. Well, you know what? The Patent Office actually publishes their response times. And I haven't checked recently. I don't want to take too much time and research it, but you can go look. USPTO.gov, they have to report how long they take. I will just tell you that from my notion, if you file normally, right, normal filing, 9 months. 9 months to 12 months is typical response time. If you file track 1 or priority examination, or you fall into what we talked about last week, which is qualifying for special status, we're looking at 3 to 6 months. So pretty quick. In fact, it sounds like faster than the trademark examiners are getting back. So it can be quite speedy, which you may have to pay for it or qualify or petition to make your application special to get that quicker response. You are totally correct. So as soon as you file either a PPA or an NPA or a DPA, design patent application, I should also mention plant patent applications, which is the most rare type of application. Immediately upon getting a filing receipt, electronic filing receipt, you're patent pending. And you should clearly label that on any physical products or any digital products, including any renderings, PDFs, flyers, to clearly identify that the subject matter that you filed is now patent pending. What that does is two things. What it puts customers on notice. Hey, this is something valuable. It's nice. It's novel. But someone actually saw put enough energy into filing this. But moreover, it puts those bad actors, those people that'll rip you off, on constructive notice. And you could potentially go after them for litigation and have them be willful infringers, where you might get triple damages on that potential infringement. So thanks for that question, Mark, and keep those questions coming. Let's jump to the patent side. I thought I had 3 questions on trademark, but I took a look at some of those and they were a little bit too goofy, even too goofy for this show, Matt. A little outside of what we're normally looking for. Oh, here it is. It moved over to the patent side. Okay, well, I'll go for it. So this question is from Richmond, Virginia. You're welcome, Mark.
It's where I went to college. Bring it on.
Oh, is it? Okay, okay. Maybe you went to school with this individual. How? Isn't it a criminal offense if someone patents the way I speak, dress my literal mind up, describe it to each and every detail, and call it intellectual property? Well, and this is one I was thinking I might skip over, but I'm going to try to address it. The way I speak, or make up your mind. Well, no. If it qualifies and is eligible for patent protection, it is not. Let me take a full step back. I believe, okay, patent protection and and the legalities for acting on that invention are 2 very separate things. I do believe there have been many inventions, products, methods, devices that are illegal if you were to actually go make it and sell it. So you can. I think this is a great question, that you can actually get a patent for producing the method of making something that's illegal to actually make and sell, with the hopes potentially that you might be able, that it someday might become legal. And I think there are some examples we could look at in the cannabis field where there were likely a lot of devices, that their most interesting benefit was for the consumption with cannabis. But of course, they were sold as paraphernalia for tobacco or other products. So it was a device that if it was used with cannabis, it would have been illegal at the time. And many states, of course, have legalized cannabis. So maybe that's a good, clear example of a device that when the device was patented, it was not legal to use for all potential uses, even the best use. It was not legal to do that. So I think that's true. That now, in terms of patenting the way someone speaks, make up your mind that I can't think of anything right now that comes to mind that would be able to control the way you speak. And so I there's nothing that on the patent side. There's no ability for you to get a patent on any natural law, okay, or any law of nature, right? And so human speech, gravity, voice, your actual human thought, those are laws of nature. And so you cannot get patents on laws of nature. And so to that degree, I would say no, they're not going to be able to get a patent, and therefore there won't be any need to address whether there's a criminal offense. Matt, I'll bring you back on. Do you have anything to add to that?
No, it's a complicated question with a good answer.
Okay.
Yeah, and like I always tell clients, there's no bad question, just bad answers. So I'll try not to give you a bad answer. Where my mind goes when we talk about, like characters and stories and things like that, or from novels, from movies, like character in a TV series. right? That actually goes to copyright. I mean, if you have a character in a story who's sufficiently fleshed out, that character is actually the character is actually can be a copyright, right? So nobody can use a derivative copy of your character in their own works of art. And I don't think you can do that with like someone's personality, for example, your personality. But it's interesting to note that characters or caricatures of people can be sufficiently unique and creative enough to warrant copyright protection.
Absolutely. Like if I were to cartoonize you, Mr. Matt Colsett, and put a cartoon with the glasses, got kind of the blonde hair with the swoop, with the checkered. I mean, that you've got a persona, you've got a real artistic nature about you. But you could definitely develop a some sort of an artistic portrayal, and that even if someone were to infringe and use that without your permission, still wouldn't be criminal. Okay, it would be a tort.
Correct.
I do have to go back to law school, and not be a crime. In other words, there's no patent police, trademark police. You're not going to do prison time for that, but you might be certainly financially on the hook and have to pay legal fees, settlements, court costs, attorney costs. Good question. They got my mind thinking a lot. Timothy Grimes has got a live question. Would I be able to license a product during a USPTO office action? You bet. You can get a license deal done while a patent is pending. That happens a lot. The negotiation depends on who your potential licensee is, right? If someone is interested, if they've seen the invention, the application is written, maybe they've had their own attorneys look at it, and even if the examiner has rejected it for some reason, in most cases, you can overcome the rejection with the legal argument or minor amendments. So an office action is not the end of the day. You've got a viable application that's pending, and that, depending on what the licensee is looking at or how you present or sell it, will eventually matriculate into a full granted patent. So you bet you can definitely license a product while it's pending. And one quick note on that is say that many licensees, people that buy patents, licensors, they want to know that there's several patents that are pending. Even if your parent patent application is granted, they like to know that there's one that's still pending so they can file for additional claims that their competitors, as they pop up, will be able to claim on those additional embodiments or versions of that invention. So thanks for that question, Timothy. Okay, one more question and we'll wrap up. This one's out of, do you want to do Dallas, Texas or Medford, Oregon?
Gentleman's choice.
Let's go Medford, closer to where I'm at. It's got some dollars in here. Oh, this one could be a whole episode.
I think we can do that in 2 minutes, huh?
Yeah, let's do a whole episode in 2 minutes. All right. Is Davison a trustworthy invention company? I'm a little biased. I'm in the middle of paying for my invention to be manufactured and marketed. I've already paid over $7,500 and 0 cents with a balance of $4,600 left to pay. Look, all I would say is you need to know. Go ahead, Matt. Go ahead, Matt. Go ahead. You need to start this one.
No, I'm good. Thanks.
Okay. Everyone, every customer, I believe, owes it to themselves to due diligence on a company prior to hiring them. And of course, you don't necessarily know who it is you're working with or how much or how good quality they do before you start, but you got to know what kind of company they are. The one thing that does irk me about these types of companies, while there certainly can be some good service provided by them, is they can be a little deceptive. And in other words, you need to make sure that when you know you're hiring a law firm versus a non-legal entity. And as long as you know that going into it, that you're hiring a company, a patent promotion company, a marketing company like Davison, as long as you know full well that they're not attorneys and they're not going to give you legal advice, that's fine. And the money, honestly, that doesn't necessarily matter. You're going to get the value of it. And whether that's fair, it's up to you to kind of shop competition and to just know what's right for you. So that's the only thing I worry about about a lot of inventors. They will go to these types of companies first, I do believe in my heart that it's important that you work with an attorney first to get legal advice up front. That's really important to get that legal advice, have that footing. And then if you decide to go off and hire a marketing company after that, excellent. That's a great thing to do, and they can definitely provide value. That's all I would say about that. Matt, any final comments on it?
No, I think you nailed it. I think oftentimes we see it on the trademark side too. There are companies out there who tend to blur the line between legal services and marketing services, and that's really confusing for clients.
Absolutely. Yeah. I don't want to knock them. They do provide good service for a lot of people, but I won't lie either, saying that we do get a lot of what I'll call these types of company dropouts, where they find out, what, they're not a law firm? Oh my gosh, what? I'm not getting a patent. I'm not getting a trademark. How is this helping me? And we end up helping them after the fact, and it can be painful to some of those stories. So hope that helps for that question asker. We'll get that out to you on Avo. That's it, Matt. It was a quick week, but thank you again for being on. We'll see you guys all next week. I've got a special guest. We've got a business attorney coming on again, and we'll have hopefully another client as well if things work out. So Matt, have a great rest of your day and have a good week. We'll say goodbye to you all. Have a great rest of your day, everybody. Go big, go bold.